Welcome to the AIS Build a Better Contractor webinar, Don't Get Caught in the Act. The new Construction Act comes into force on the 1st of October 2011 in England and Wales, and a month later on the 1st of November in Scotland. This webinar, part of our Build a Better Contractor programme, is a guide to the changes brought about by the new Act and the main changes that are likely to affect your business, the implications they may have, and how not to get caught in the act. Our presenter today is Geraldine Fleming, Vice President and Executive Director at Knowles, a Hill international company. Knowles are an AIS service provider and provide us with construction consultancy and legal services to our members. Should you have any questions that arise during the webinar, please type them in the questions box in the webinar control panel and click Send to forward them to me, so I can ask Geraldine for an online answer at the end of the webinar. I now hand over to Geraldine Fleming for the Don't Get Caught Act in the webinar.
Thank you very much, Robert. Hello everyone, and I'm delighted to welcome you to this Knowles workshop on the Construction Act 2009. From Knowles' perspective, this has proved to be an extremely popular course, and we estimate that by the end of September we will have given this seminar to around 1,000 people, and it's by far the most popular subject that we've had since the original Act was introduced. In terms of timing, I'm aiming for a seminar length of about 40 minutes and then hopefully some questions afterwards. We look forward to listening to the delegates' questions. You'll see on the handouts on your screens at the moment that you've now, in front of you, you've got our corporate overview slide. I don't intend to go through this in the detail that you can see on the screen, but I'd just like to point out that the company that I work for is Knowles, and we're owned by an American-based company called Hill International. And I'd like to emphasize that Knowles has been in existence for almost 40 years, and we are a leading name in construction disputes. In fact, because of our association with Hill International, our parent company, actually we are the global leader in construction disputes. Our work splits into three distinct areas: dispute avoidance, dispute resolution, and dispute management. And as far as I'm concerned today, today's seminar is about avoiding disputes, and it's certainly something that Knowles can help you with. So we're looking here at contractual advice and contract drafting, procurement and partnering advice, looking at defects diagnosis, and also workshops, and of course seminars and training. If things do go wrong, obviously we can also help you on the dispute resolution and the dispute management side, whether that's actually acting for you in adjudication as the claimant or indeed as the defendant, or looking at expert witness work or litigation support work. A little bit about me. You can see a few brief details on the slide now in front of you, slide 4. I have a degree in quantity surveying and I'm a chartered quantity surveyor. I worked for a main contractor for 5 years as a site QS, so I definitely know the relationships between employers and main contractors, and obviously down the line main contractors to subcontractors, and from my experience at Knowles, further down the line than that. I've also gone on and completed a law degree in 2002 and completed my solicitor's exams in 2004. I've now worked for Knowles since 1997, so a significant period of time, and my job title is Vice President and Executive Director. In terms of my responsibility and role within the organisation, I guess that I probably give a full-day seminar, full-day workshop once a fortnight, and the rest of the time I'm giving contractual advice to people like yourselves. So starting off and looking now in detail at the changes introduced by the Construction Act 2009, it's important that we actually set the scene. And a good starting point when discussing the Act is to remind ourselves about its initial purpose. So in other words, why was the original Construction Act brought into play? Well, the original Construction Act, which was its full title is the Housing Grants Construction and Regeneration Act 1996. I'm going to refer to that from now on as Construction Act 1996. 1996, well, the main purpose of that legislation was to improve cash flow in the construction industry following a report by Sir Michael Latham. And that report was written and produced in 1994. And actually the Act, the Construction Act 96, came into force pretty quickly following the report. It was drafted and there was consultation 1996, and it actually came into force in May 1998. So it's now been in force for a significant period of time. However, the parliamentary wheels have slowed down a bit since the original impetus for this Act. Changes were proposed in 2004, resulting in a significant amount of consultation. We then had the Construction Act 2009, and as Robert mentioned right at the start of the seminar, in England and Wales, the Construction Act comes into play on the 1st of October 2011. The new Act, the Construction Act 2009, again, let's give it its full title, the Local Democracy, Economic Development and Construction Act. It's actually a pretty small piece of legislation. And it's important to realise exactly what this means and how you should react to it. It's actually an amending piece of legislation. And in order to understand it properly, you need to have the original Construction Act 1996, and you need these amendments, which are contained in sections 138 to section 145 of Part 8 of the Act. So the Construction Act 2009 comes into force on the 1st of October in England and Wales. It's highly important that you realise what this actually means. Any contracts that you already have running, or any contracts that you enter into prior to the 1st of October, will be on the old rules, the Construction Act 1996. Any contracts that you enter into on or after the 1st of October 2011, they will be on the new piece of legislation. So pre-1st of October 2011, well, it's still on the Construction Act 1996. On or post the 1st of October, we're on this new system. I have to admit, I do feel sorry for main contractors in relation to this, because they may well find themselves in a situation where they're currently working for a client. The contract has been entered into already. They may indeed have procured the first 5 subcontractors on the project, and themselves and those 5 subcontractors will be on the old rules, the 1996 Act. If they then procure more subcontractors post the 1st of October, those new subcontractors will be on the new rules. And as you'll see from this seminar, goodness, that could be a very complicated situation. And just to make things just that little bit more interesting, we have a different in-force date in Scotland. So those of you who are listening who have any connections at all with Scotland, you've got subcontractors up there, or indeed the project is in Scotland, that comes into force on the 1st of November 2011. So the guys in Scotland have an extra month's grace. After the webinar, we will be sending all delegates a copy of these notes and also a document that usefully highlights the changes to the original Construction Act 1996 and also the changes to the Scheme for Construction Contracts, which were actually only approved in early September 2011. So, in summary, we've got Construction Act 1996, which is amended by Construction Act 2009.